Hi, welcome to LAWBY Podcast. Today, let's see what consent is and how it forms part in various fields of law. Let's assume you agree to sell your house to a friend. You own two houses, that is, a villa and a flat. Your friend thinks he is buying the villa, but you actually intend to sell your flat. In this case, you and your friend did not agree on the same thing in the same sense. As a result, there is no consent. Consent, in simple terms, means giving consent to a person for the performance of an act at one's own will. Consent under Indian Contracts Act. Section 13 of the Indian Contracts Act defines consent as when two parties entered into a contract, they should agree upon the same thing in the same manner. There should be a meeting of minds between the two parties. If there is no consensus ad idem, meeting of minds, on the material terms of the contract, then such contract will be void. Section 14 defines free consent as consent which is not a result of any of the following, namely coercion, undue influence, misrepresentation, fraud, and mistake. Let's now take the above example of you wanting to sell your house. If you threaten your friend to agree upon a particular price to buy the house, then the consent is said to be obtained by coercion. In the same scenario, if you are a rich person and you force a poor person to buy your house valued at Rs 2 lakhs at Rs 4 lakhs, then you would be using undue influence. If you sell your house claiming it to be fully furnished, while in reality it is unfurnished, you would be committing fraud and the contract would be voidable at the option of the other party. Suppose you intend to sell your cow to your friend and say, "My cow is perfectly sound." Your friend genuinely believes the cow to be sound, although he does not know that the cow had fallen sick the previous day and thereupon buys the cow. Now, there is misrepresentation on your part. You want to sell your house to your friend for Rs 2,80,000, but by mistake you make an offer at Rs 2,60,000, which he accepts. Now, you cannot cancel the contract on the ground that you have committed a mistake about the price. Now, let's look at consent in criminal law. In the Indian Penal Code, the term free consent is not mentioned anywhere, but there is section 90 of the code which states that what does not amount to free consent. According to section 90, a consent is not such as is intended by any section of this code if the consent is given by a person under fear of injury or a misconception of fact, and if the person performing the act knows or has reason to believe that the consent was given as a result of such fear or misconception. This means that every such consent which is either obtained under threat or fear of injury or the act which causes it is done under the threat of fear by an insane person or by any child under the age of 12 shall not constitute consent under this code. Consent in cases of marital rape. Section 375 of the Indian Penal Code nowhere mentions the provisions related to rape with the wife. However, it has always been assumed that the husband does not need the consent of his wife during sexual intercourse. Indian law is silent on the consent of the wife, whether the wife has given consent for sexual intercourse or not. But the Supreme Court in the Chairman Railway Board vs. Chandriman Das held that the act of committing rape is a gross violation of basic human dignity and the harm to the women's dignity. The judgment of right to privacy also talks about personal liberty and right to privacy. The same is applicable to all types of rape, including marital rape, where the wife has the right to denial of sexual intercourse with the husband. Article 21 of the Indian Constitution speaks about personal rights and liberty. However, unfortunately, when it comes to marital rape, this very right is snatched away as it is assumed that with the consent to marry, the wife has also given a lifelong consent for sex with a husband, irrespective of the physical, emotional, and psychological circumstances. This perspective, however, needs to be changed so that the wife can deny sexual intercourse with the husband. Right to life under Article 21 also includes right to deny, but with the current social pattern prevailing in the society, this fundamental right has often been ignored, and also the consent of the wife has not been taken into account. Therefore, free consent in cases of marital rape is undefined and vague in the Indian context, and therefore one cannot say that there is consent of wife during sexual intercourse or not. What does consent mean? The Sexual Offences Act 2003 says that someone consents to a sexual activity if they agree by choice and have both the freedom and the capacity to make that choice. If someone says no to any kind of sexual activity, they are not agreeing to it. But if someone does not say no out loud, that does not automatically mean that they have agreed to it. The Nirbhaya Act or Criminal Law Amendment Act 2013 defines consent as the unequivocal voluntary agreement to participate in a sexual act. This means that there needs to be a clear expression of willingness to participate. The Act further clarifies that the absence of resistance will not imply consent. This means that consent does not have to be spoken and there is no need for her to say no explicitly. Women can show the lack of consent through other ways such as gestures. Now, let's move on to consent to treatment. Informed consent means an agreement, compliance or permission given voluntarily without any compulsion. It can be defined as the voluntary and revocable agreement of a competent individual to participate in a therapeutic or research procedure based on an adequate understanding of its nature, purpose and implications. It is also a fundamental and an established principle in Indian law. Self-defense of the body provides the right to protection of bodily integrity against invasion by others. All medical procedures, including examinations, diagnostic procedures and medical research on patients in the absence of consent, constitute an assault under Section 351 of the Indian Penal Code, for which he is liable to pay damages. This is true except in cases of emergencies where the patient is unconscious and where it is necessary to operate before the consent can be obtained. For practical purposes, we divide consent into implied and expressed form depending upon the circumstances. Implied consent. This is the trust and the empathy that a patient develops with the doctor when he first comes in contact, and due to this empathy, he allows the history and examination of himself. This empathy and trust forms the basis of implied consent and is the most commonly employed type of consent in general and medical setup. Expressed consent. An expressed consent can be written or verbal. This is taken when any material risk is involved. Expressed consent includes informed consent, which is the ideal form of consent because it includes all aspects of meaningful decision making where the person can make a balanced judgment. What needs to be disclosed? The doctor's legal duty. The informed consent from a legal perspective generally requires the discussion of the following. 1. The patient's diagnosis. 2. The nature and purpose of the proposed treatment or procedure. 3. The risks and the benefits of a proposed treatment or procedure. 4. Alternatives and associated risks and benefits. 5. The risks and benefits of not receiving or undergoing a particular treatment or procedure. 6. The special precautions required. 7. What the doctor recommends. It is essential that this information be discussed in simple terminology that can be readily understood by the patient. It is also essential that the patient be given an opportunity to ask questions about his or her conditions and the proposed treatment or surgery. Requirements for valid informed consent. The practice of medicine is extraordinarily complex and difficult and with little margin for error. In most situations, the doctor cannot act without a patient's informed consent. In order for patient's consent to be informed and thus valid, they must be able to make a well-informed logical decision. If they agree to a treatment, understanding what it involves, they have given informed consent. Informed consent was practically non-existent till the time COPRA, that is the Consumer Protection Act, came into existence. This is seen as a legal requirement than the ethical moral obligation on part of the doctor towards the patient. The Supreme Court of India in the Samaira Kohli case stated that consent in the context of a doctor-patient relationship is defined as grant of permission by the patient for an act to be carried out by the doctor, such as diagnostic, surgical or therapeutic procedure. Consent can be implied in some circumstances from the actions of the patient. This order gives the principles of consent with regard to medical treatment and therapeutic investigations and not for medical research or clinical trial as follows. 1. A doctor has to seek and secure the consent of the patient before commencing a treatment. The consent so obtained should be real and valid. The consent should be voluntary, and the consent should be on the basis of adequate information concerning the nature of the treatment or the procedure. Number 2. A balance should be maintained between the need for disclosing necessary and adequate information and at the same time avoid the possibility of the patient being deterred from agreeing to a necessary treatment or offering to undergo an unnecessary treatment. Number 3. Consent given only for a diagnostic procedure cannot be considered as consent for treatment. Consent given for a specific treatment procedure is not valid for some other treatment or procedure. Number 4. There can be a common consent for diagnostic and operative procedures where they are contemplated. There can also be a common consent for a particular surgical procedure and an additional or further procedure that may become necessary during the course of surgery. The nature and extent of information to be furnished by the doctor to the patient. In the case of Muthukrishnan versus M. Rajya-Lakshmi, it was held that there are no clear principles or regulations developed in India where the patient is unable to give consent himself. If such a situation exists, the medical practitioner may proceed with the treatment by taking the consent of any relative of the patient or even the attendant. In this case, the wife of the patient informed the hospital authorities in unambiguous terms that she had no objection to her husband undergoing bypass surgery. Her consent was deemed sufficient for the purpose of any formalities with which the hospital was required to comply. Now let's move on to the conclusion. Consent is absolutely important to make an agreement with a valid contract. The importance of consent cannot be stressed enough. The parties' consent must be free and voluntary. It is necessary to give consent to the contract without any pressure or delusion. It is essential that the parties' consent is free, as this may affect the validity of the contract. That's it for the day. Thank you for listening to us. Subscribe and support us. Stay tuned, stay lobbyfied.